All right, well, our first trio is William Daly, Will Bode, and Richard Ray.
Thanks for the paper. I think it's has all the virtues that Mitch said that it has. So these questions are friendly to the project. It does feel a little bit like two papers that could be more tightly connected. It seems that in your rightful humility to want to say, we're not saying natural law requires the US Constitution or requires these things, you seem afraid to say too much and then say, I think, less than you might have. And one way I've been thinking about it is that something natural lawyers talk about are virtues. So if the choices of the framers weren't forced by natural law, required entailments of it, as it were, they still evince virtues of the natural law, and you could probably tease those out, and maybe the two sections of the paper might be united and natural law might not disappear as much as it felt as it did in the second half of the paper to me, though that may have just been my impression. Thinking, in fact, of Justice Scalia and his relationship to all these things, some of those virtues that are reflected in the second half of the paper are the attention to structures, right? So it may not be that the structures and the separation of powers that we have are entailments of a natural law approach, but they may have virtues that natural law suggests are really important for good legal systems. They might be better choices rather than worse, and that's still worth something, even if one doesn't say, once you're a natural lawyer, it turns out what you want is what we've got. Textualism, it's true that the written text isn't the law, but there's a lot of emphasis on the writtenness of the text being important to law, a virtue that, again, may have something to do with the promulgation point that you draw out. So I think that there are ways in which the paper might speak a little bit more about what emerges from considering natural law and constitutions, and maybe, again, consider alternatives. Is the Canadian promulgated commitment, at least promulgated by its Supreme Court, right, to a living constitutionalism, does that run contrary to virtues suggested by natural law? So maybe thinking a little bit about other constitutions and their relationship to natural law could help as well.
So I was wondering if you could tell us a little bit more about how enduring this enduring originalism really is. So, here we are in California. There's more than one kind of stipulated positive law here. So I think we were once governed by the 1824 Mexican Constitution, and then again by the authoritarian 1836 Mexican Constitution that replaced the 1824 Mexican Constitution, and then, eventually by U.S. law. And those seem like all categories of stipulated positive law that are sort of out there for the taking. Now, obviously, you have these things in your paper you say about sort of why it's the constitutional order in particular. Sometimes it's a reference to as long as the legal system ordered by the Constitution is there. In other places, it's a reference to the text. But I wasn't quite sure on sort of the enduring originalism theory. What would it take for originalism to no longer be the law under this theory? And in particular, sort of, David Strauss is out there, and you talk about him a little bit, and your remarks also actually seem more open to the possibility that there has already been a Straussian revolution than I expected. So if somebody could show you that, indeed, like the text of the Constitution just doesn't govern most important questions in law, would that be enough? My cab driver told me that he thinks the law is the Supreme Court just does what it does and everybody follows it. And if that's what most people think it is that enough for originalism no longer to endure? I know what the positivist answers to those questions are, and that's sort of what Steve and I tried to write, even if it wasn't persuasive. But I'm not sure what yours is.
Really enjoyed the piece. I wanted to ask about the brief discussion of oath theorists and your criticism of oath theory. And so I had a couple different questions about it. So one thing you say briefly is that it might be an impeachable violation of the oath in the event that there's any interpretive change in practice, and that strikes me as a remarkable possibility, but to be a separate kind of inquiry. How we remediate or respond or enforce moral duties related to the law is a fascinating, important thing, but it's a separate inquiry from whether the moral duty exists and what its content is. And I think that if you're going to go there in connection with oath theory, then you might want to consider how you might go there under your own approach. I mean, in other words, for example, are you contending that impeachment is a means of enforcing the natural law originalism that you advocate? That's just a small point, but I'd be curious to hear your reaction. The second point is, if we're talking about the pros and cons of being an oath theorist or a natural law originalist, I wonder if we should consider the difference, the trade-offs maybe between how determined the theory is, or how thick the theory is, and how universally appealable, how universal its appeal is. So I think, as Mitch said, it's not always clear to me when reading this how much actually depends on being a natural lawyer to agree with your account. I actually think that many of your pragmatic points could appeal to a wide pragmatic audience. But to the extent that you are, especially to the extent that you are dressing this in natural law garb, it strikes me that its audience is limited, at least in the first instance, until people read the paper and are persuaded by it. Whereas by contrast, the oath has very broad, maybe it's even the most universally attractive moral principle that we should keep our promises. So the last question I had is about the real gist of your criticism of the oath, which is that which has to do with having to operate at a high level of generality. And this goes a little bit to Will's point about how enduring is your approach, because again, I would think it would be a comparative inquiry. How enduring is enduring originalism? And we have to consider, in comparison, the stability benefits or costs of the oath. So I would think, so like Will, I'm not entirely sure how stable your approach is. But I would add to that if we think about the oath, it has a built-in system for stability and persistence over time, because people take oaths on a gradualist basis as part of a continuous legal culture. Now, I agree that if there were a radical rupture in the meaning of our constitutional practices and our understanding of the Constitution, or whatever we understand the law to be, then that would eventually, maybe even precipitously, have an effect on the moral content of the oath. But it strikes me, this is, again, goes to Will's point, it strikes me that same possibility arises under your approach. And indeed, it may even be more acute of a problem on your approach, because while the oath allows for commitment to higher and lower level principles of law, per Will and Steve, your approach seems to go a step further and have these two qualitatively different types of law, which I would think would only tend to exacerbate instability rather than the opposite. So, again, thank you for the piece.
I'll start. First, Bill, your comments, they're friendly amendments that are well taken. I guess we want to be modest in saying, we don't want to perform the natural law version of our perfect Constitution and say, the natural law gives us bicameralism and presentment and this. But yeah, it's worth noting the virtues of some of the, people, framers make choices in light that are influenced, but not determined by moral reasoning, and it's worth identifying what is good about what we have, and those give further. So you have reasons to kind of follow the law, not just because it's the law and it's good to have law, but a lot of times some of the law serves good features and serve good purposes, and it's good to understand that and appreciate it, and that can help bridge the gap between the two texts. I probably want to read a little bit more on. I think Lee Strang has written about virtue ethics and originalism. Maybe some of Larry's work on judicial virtues along those lines might be helpful as well. With Kevin, do you want to weigh in, or do you want me to keep going?
Well, I can answer Will's question, or if you want to.
Yeah, go for it.
Will, this is an excellent question, right? It's tell us more about how enduring this originalism is. And this is where I think there is a fair amount of dovetailing with both what you argue and with what Steve argued, right? You guys point to the higher order argumentative practices. You distinguish between higher order and lower order. You look at cases and the things like that. I think when you stop seeing the kind of higher order things, right, like to what purpose is a constitution written, that that its limits, other than that its limits may be enforced, when you stop seeing those sorts of things, then yes, that originalism is gone. I think what we're adding is, in the interim, while that is happening, while we're seeing a sort of ongoing revolution, we're offering a way to say the people who aren't using those higher order principles are just doing it wrong because of the kind of constitution that we have, and not simply because we've been doing it that way for a while, or enough people have been doing it that way. This way of looking at the Constitution as stipulated positive law is essentially attached to our particular Constitution, such that its legitimacy is not simply a matter of acceptance. So that as even when 90% of people are looking at the Constitution as a source of inspiration and the like, we will still insist you're still doing it wrong under our positive law right now. But once we can't appeal to that anymore, then yes, it is gone.
And I'll talk to Richard. Richard's points. Really good questions here. I'll take them not in direct order, but one question is thickness a virtue or a vice here, right? The oath has, kind of more minimal commitments. We all think promising is a good thing. Why do I have to buy into the metaphysics of the natural law tradition, right? To get on the originalist train, right? One answer might be, and I get this reading partially from you see this in reading Larry's paper, is or Larry Sullivan's paper, or reading Larry Alexander's stuff on originalism. The case for originalism could be overdetermined from a number of moral theories. And one thing our paper brings to light is we kind of get a kick out of flipping the association of natural law with non-formalist constitutional interpretation. We're saying, look, everyone associates the natural law with kind of quasi-Dworkinian stuff or Hadley-Archies, and the unjust law is no law thing. Part of our intervention is to say, actually, there's a lot of resources in the tradition to ground reasonably durable formalist approaches to law, and so it's partially kind of just kind of like letting the rest of the world know that the natural law tradition is more complicated than you think, and has more play and is more plausible in terms of ordinary kind of common sense about how we think about law and its durability. And you don't have to buy the metaphysics to buy the argument. It's the approach that we think happens to be good. And there's an audience question. Are we writing for natural lawyers and saying you should be originalists? Yeah, I guess kind of. Are we writing to originalists to say you should be natural lawyers? I mean, the point of this paper is not to make you a natural lawyer, for sure. But it's to say, look, here's another long-standing tradition that happens to look a heck of a lot like the tradition the framers are working in to ground this approach. So some people may get off the train because of the thickness, but it's an approach that we happen to be think is right. So from like a selling, marketing perspective, well, that's a problem. But we're gonna introduce it to the argument. The oath, and I guess the impeachment language is kind of a flip aside, and I will take that out, and I'm responsible for that one, not Kevin. I absolve him from that. So I guess what I was trying to get at, in kind of poorly articulating, is an idea of how I'm still kind of grappling with the idea of how change works under the oath. How development or how interpretive regimes can change over time. If you kind of swear to uphold a particular set of norms and it changes over time, is it by accident? Is it by not following the oath? And it just seems I was just kind of and so there either seems to be kind of change seems to be either have to be kind of identified to kind of accidental violations of the oath or intentional ones, or if you're being faithful to the oath, what your obligations are at a very high level of generality. Then I'm not sure what the oath is doing, particularly if you're in a context of theoretical disagreement about what our Constitution is. I think our approach, I think, is oath compatible for sure. I think our approach says, well, here's why it's a good thing for you to swear this oath, right? This is why we ask you to do it, right? And this is why it is a good thing to swear people to uphold the law of this Constitution. And you can come at that from that's an area of overlapping consensus, but we're part of that consensus. And we can also make an argument that you should uphold our Constitution, even if you're not, even if you don't have to swear an oath. And so we look at that as a feature as well. But I'll make that language more charitable and more clear. I don't want to. It was not intended to come off as dismissive.
Just very briefly, I didn't quite understand Kevin's response to Will, I thought that the stipulated Constitution endures forever, so long as we're under the same legal regime. I thought Jeff's answer was a little different, which is once we've gone far enough down and we're really in customary law land, then the practically reasonable interpreter wouldn't have good reason on balance to go with, to endorse or apply the stipulated law. But I thought that.
Well, I think we look at that as essentially a new regime.
Thanks.
All right, the next trio is Richard Fallon, Michael Ramsey, and David Upham.
I enjoyed the paper, and I am quite in sympathy with some parts of it, not all of it. I've got 4 questions. That seems like a lot, but they're just rat-a-tat-tat. I'm just going to send them right out there. First, the way I understand the paper, it treats as the right question for all of us to be thinking about is how should we understand the law such that we should obey it. And I wondered if you would agree with that formulation. Second, if anything like that is the right question, then it can't be the case that slaw and claw or whatever stand on the same footing. Because they can't both be the law in the sense that we ought to be concerned about law, which is what's the law such that we ought to obey it. So some choice has to be made. Isn't that right? Third question, if we have to choose, does the choice have to be all or nothing? That is, do we have to go all claw, all slaw, or might the law be such that we would have most reason to want to obey it if it were some mixture of claw and slaw? And then fourth, if you agree that it could be a mixture, which would be my own view, then how different is your approach from essentially a multiple modalities approach?
Yeah, well, I'm not sure, but what Richard Ray already asked this question, but I'm going to ask it anyway, which is, and I only have one question, but it's sort of a bigger one, sort of a basic one in a way, I guess, which is that I'm sort of struggling to see what natural law adds to the argument, in the sense that you have arguments, especially at the end of the paper, that seem to me don't really sound in natural law so much. They sound a lot to me in pragmatism. But to maybe to set that up a little bit, so at the outset you talk about the proposition that we follow the law until it's changed by an authoritative change. But I don't see why, just from the sort of the natural law perspective, why the authoritative change can't be the court. Saying that this is our change, and this is the new rule. And then we follow that. And in fact, that seems to me to be somewhat descriptive of the system that we have. If we ask the question, why do we have, why is there a constitutional right to same-sex marriage? The answer is, the court said so. Now, I think there's various ways you can push back against that, but I don't understand why the way that you push back against that is to say we have an obligation to stipulated law, because that is the stipulated law under a certain object. It depends on who you think has the authority to stipulate the law, and I don't see how natural law gets me anywhere in wrestling with that question. Because any stipulated law is going to have the ability to change. And so the only question is, even within this framework, who has the authority to change it? Or who ought to have the authority to change it, depending on how you want to look at it. So it seems to me that if you're asking a positive question, you're sort of asking, who does our society understand to have the authority to change it? And your answer might be the Supreme Court. I don't know. Or if you're asking a normative question, or as Mitch wants to say, a moral question, who ought to have the authority to change it? And I have some views about that. But it's not clear to me, and my views actually, I'm very sympathetic to where you come out actually, but not. I'm struggling to understand what natural law would say to me that would make me more confident than I already am about what those answers should be.
Just 2 points. One, I'm very favorable to your project and to your arguments here. I wanted to suggest something about in terms of making it somewhat more persuasive, and that is when you speak about the natural law tradition or classical natural law and its compatibility with the Constitution. I just suggest it might be more persuasive to focus on founding era natural lawyers like James Wilson or Blackstone or something, simply because it's more persuasive to begin to suggest the relevance of natural law to the Constitution by showing the convergence of among jurists. But they seem to be both originalists, even though I don't use the term, or they constitutionalists at least, but also say something about nature, natural rights, and law. A second point, and it may simply be far beyond what you want to do in this paper, but it is at least relevant to the project, and that is natural law tradition, broadly understood, isn't merely a theory of the relationship between reason, natural reason, and law, but also it's not just theory. It's a theory also of recognition. It's an epistemology that human beings generally know things. And when you say that, assert that in terms of the more fundamental principles, like don't torture children, we brought that up yesterday, that human beings by nature apprehend these things, I think that has profound implications for among other things, for restraining judges. If judges come up with some new theory that nobody else came up with before, there should be a caution that they've discovered new natural reasons. It may very well be that they're doing something that's just weird, rather than something that's consistent with. And it also is something of an argument for a certain measure of presumption favoring customary law or law that's been deliberated and chosen by the people at large. As I say, there's an argument for democracy, as well as for long-standing judicial precedent, from the very epistemology that says that human beings get stuff by nature.
All right, we'll take them in reverse. I'll take David and Mike, and I'll let Kevin go with Dick Fallon.
That's fine, but I'm not doing his in reverse.
That's fine. Yeah, you should do his in order, because it'd be really weird to do it the other way. You don't want to bury. We don't want to finish the lead. David, talking about more founding era natural lawyers, especially Wilson and Blackstone, you're absolutely right. That further emphasizes the fact that we're not doing some sort of, anachronistic, obscurantist project. So you're absolutely right there. I need to think more about the fact that natural law indicates that, certain things are accessible to reason, and if something is radically, new and radical innovation, that we should, we might want to be suspicious. There's kind of interesting confluence of Burkeanism with natural law reasoning there, and I could definitely see the argument about how, given that people have access to reason, that democracy on balance is better than non-democracy. That sounds certainly plausible to me, and we need to think about it more and figure out how we can kind of work that into the paper. Mike, what does natural law add to the mix? Are we actually, do we start off as natural lawyers and fall away and become pragmatists, or who has the authority to change, and what does the natural law tell us about that? I think what we want to kind of bring it in at the first stage is, we would say, the natural law reasoning gives us. The natural law gives us very strong reasons to be very faithful to our particular constitution, right? And if we think the best reading of our original Constitution until, lawfully changed, and I'll tell you what lawfully changed means, is that, the proper way of changing it is through amendment and, liquidation within reason or something like that. If that's the rules of the game that were posited as law that we have a moral obligation to obey, change that's inconsistent with the Constitution, that violates the constraint principle or something like that, would be a violation of those rules. And these rules, which we think that natural law gives us a strongly presumptive obligation to follow. If you have a constitution, so imagine you have a constitution that says judges get to decide, right? And it's posited, and it's as a framer, it's not one I would pick, right? But let's stipulate that it doesn't overcome the moral obligation to obey the law. Well, then the judges are the authoritative changers, right? Until everyone decides, reasonably or not, to initiate a new legal regime. And the choice about whether to initiate a legal regime is a moral one. And we'd have to say this old regime is insufficiently good that we're going to kind of disrupt and change, right? So if we believe the original law did not authorize radical judicial change of the Constitution, and points towards originalist conventions or law of interpretation, that gives you the answer about why you should be an originalist, at least with respect to the kind of Constitution that we have. And Kevin, with respect to Dick.
Sure. Yeah. I think I got them all down in rat-a-tat. My note-taking may have faltered, but as I have it, the first question is, are you asking something, are you, Jeff and Kevin, asking something like, how should we understand what the Constitution of the United States is, such that we should follow it to get the benefits natural law theorists have explained? And I think the answer is, in a sense, yes, right? Here is what we're doing. We're surveying the legal landscape now and trying to pick out the central case of the internal point of view. And when we're doing that, we say one should view as the central case of that internal point of view the Constitution follower who understands the law of the written Constitution to be stipulated positive law. So that is a normative argument in terms of what you should view as the central case of the internal point of view. But the normative argument is contingent on the descriptive claim that the Constitution was, and more controversially, but still true, we think, remains the kind of stipulated and fixed, authoritative, stipulated positive law that natural law theory would identify as the central case of positive law. So it's a normative claim about what the central case is that rests on a descriptive account of what our Constitution is. The second question was, given once we divide between stipulated positive law and customary positive law, is it really the case that they rest on the same footing? And Dick, you expressed the skepticism, and we agree they don't stand on the same footing. Our paper, in particular part one, sets forth much more of a justification for the stipulated positive law than for the customary positive law. You can make, and others have made, types of arguments for the authoritativeness of customary law. We're not doing that with respect to our Constitution. But this gets to the next point, which is, but you still recognize that as some customary positive law as law in our system, available for choice to be implemented. Are you really pressing an all or nothing choice? And I don't take us to be pressing an all or nothing choice, which then leads to the fourth question, which is, how different is this approach from the multiple modalities, from a multiple modalities approach? I guess the most familiar multiple modalities approach, at least to me, is one in which there are no privileged modalities at all. And in fact, those are all modalities of doing the same thing, that is, generating constitutional law. in our taxonomy of the law as we see it, there is the privileged modality is that which generates what we call the law of the Constitution, as distinct from all these other types of constitutional law that we have as a matter of judicial decision and perhaps practice and other things. But our claim is that the law of the Constitution generated from this privileged modality is normative for the rest of it. Does that mean in every single case that the interpreter must choose that? Well, no. I think it will really vary depending on who's trying to do, who's acting and what they're trying to do. I'd say it varies depending where you are in the government hierarchy, whether you're a legal academic or whether you're advising the President of the United States, or whether you're a law clerk, or whether you're voting on the Supreme Court. There's going to be more law and more considerations that point you in different directions, and that's why our paper ends where it does, because we don't purport to resolve those. However, it's not one where we just throw up our hands and say, well, it's all law, there's lots of stuff out there. We are saying that the law of the Constitution is normative for the rest of it.
All right, so we've got 10 people in about 15 minutes. What would be? Let's have three of you, and let's see how far we get. So we're going to have Larry Solom, John Harrison, and Randy Burnett.
Kevin, there's lots of, and Jeff, there's lots of really wonderful stuff in this paper. I want to echo something I think other people have been saying more or less explicitly, which is I think there are two different projects going on here. One project is engaging with contemporary constitutional theory and writing about originalism, and these are the parts of the paper that were much of the focus of Mitch's comments. And I think that part of the paper stands alone as a significant and important contribution. And I think that's the most finished and fully baked part of the paper. There's a second project going on here, which is an attempt to develop a natural law constitutional theory in relationship to originalism, and to show that sort of within a broadly Phoenician approach to natural law, that there's a case for originalism. I would urge you to take a step back from that project for now. You will, and I hope you take the following thing I'm going to say very seriously. You're only going to get one shot at this. It's a very important project, and it deserves your doing it sort of in its best form. And I have a practical suggestion for you, sort of a way to step back and reapproach that project. So I think that you've got two dimensions here. So one dimension is talking about natural law reasons to accept positive law obligations under a certain range of circumstances, right? That part of the project is not fully developed. If you really want to go in a finished direction, which I think is the most promising direction for contemporary natural law theory, then I think you need to present that theory in a much more fully developed way with the full apparatus of the basic human goods and the argument from the basic human goods to the obligation to follow positive law under the right range of conditions. But there's a second part of that project, and this is, I think, radically underdeveloped in the current paper, and that is a natural law theory of interpretation, right? So there's a good model, and you talk about it very, very briefly in a footnote, right, for how this would go about, and that's the, Richard Eakin's model of theory, what is really a natural law theory of statutory interpretation. So you mention this idea, but it is absolutely key to developing a Phoenician approach, and that is you need to focus on what he would call the focal case, right, which requires a certain understanding of what a framer does, right, in writing a constitution. And then our theory of interpretation is got to be articulated with respect to the focal case, right? This is the core normative move in Eakin's theory of statutory interpretation. You may end up agreeing with Eakins or disagreeing with Eakins, but I think that a good preliminary step is to work up an Eakins-style theory of constitutional interpretation and then figure out what your stance is with respect to that. I just would suggest that the paper in its current form is not going to help the cause of developing a really a strong natural law theory of constitutional interpretation that supports originalism. There's too many things going on this paper, and the natural law part of the paper is, I think, really underdeveloped. So I would urge you taking the paper apart. I realize that's a somewhat radical suggestion, but I just think that the natural law part of the project is really important, and for that reason, you just don't want to make missteps now that you might come to regret later.
John?
The text isn't the law. Is the legal content that's not the text inherently unwritten and not capturable in words, or is that just an accident of the way the system operates and the way it makes decisions?
I just want to say my Uber driver was very proud of the fact that he knew that Scalia was Chief Justice. So, and he actually probably got the spirit of the guy more accurately than his real title. I just got in the queue because I wanted to register a note of agreement with something that Mitch Berman said, and this happens so rarely that I felt like I really ought to draw special attention to it.
This was the part about being the uncle that people should avoid?
No. Well, there's two things then. The other thing was your persnicketyness about the use of the term normative. I just think that's fantastic. I mean, it's a pet peeve of mine that academics have got into the habit of calling moral arguments normative arguments. And when I believe that terminology, and I'm not a big expert, I can't make great claims on the intellectual history here, but I think it was the decline of natural law thinking, and whenever you want to date that decline in favor of something that you might call logical positivism or whatever you want to call it. But we all know that that whole way of thinking just went down the intellectual memory hole. And then at that point, what are academics going to say when they want to talk about right and wrong and good and bad when it's not legal to talk about, it's not philosophically correct to talk about right and wrong and good and bad? And they talk, well, I'll talk about norms, because norms are an empirical fact. Norms are just what most people do, as you can just observe them, right? So we're being scientific, we're being accurate, we're not being mystical. And then at some point, morality made a comeback, and it took a while to happen. It was very gradual. The Rawls' theory of justice was such a big deal, huge deal, because all of a sudden, I mean, this was not the first time, but this was the biggest. Justice? We can't talk. Justice? Are you kidding me? But it was Rawls, and it was the big green book, and everybody carried a copy, whether they read it or not. I mean, it was such a huge deal culturally, because all of a sudden morality and justice are back. But we still say normative. And I mean, in my comment earlier today, I said normative, and this is a pet peeve of mine. I mean, this is probably because, as you all know, I'm one of these go along to get along guys. You know, but I just want to compliment you on having drawn the line there. I mean, and also commend you on your textualism and the fact that you took that word very seriously and literally, and I loved it.
Okay, so I agree with Randy on Mitch. Larry, I want to talk with you about this afterwards, since we're running short on time. I want to talk this through with you a bit more. John, can you repeat your question real quick?
Is the legal content that is separate from the text inherently unwritten such that it cannot be captured in the form of words?
Ooh, I don't know. I don't know. Kevin, do you know? I have a Deus Ex Machina here.
Yeah, well, I'm not sure I understand, but let's start with this, right? So the claim, one claim I think was made by Mitch is that the text is not the law. Is that right? Yep. So is a work being done there by the, right? So because I think the text is law, but that the law of, so the text of the Constitution is law, but the law of the Constitution is more than the text, right? So it's not the law, right? It would be a mistake to equate the text with the law, but it seems accurate to say, if you say, well, what law is that? And someone says, well, that is Article 1, Section 8, Clause 3. That is a sort of an accurate statement, right? And you say, well, what's the law of Article 1, Section 8, Clause 3? Or well, then we're going to need other law to figure that out. Have I committed the heresy that you condemn?
I'm just wondering, what is that other stuff? What form does it take?
Right. So
what does it look like? Can you put it in words?
You can put it in words. I don't know that you can capture it in a code. I mean, it's the sort of stuff that we read when judges explain what they're doing with that text and why. When they're explaining, for example, we must never forget is a constitution we're expounding. That's a claim about what it is. How you treat something as law is a function of what kind of law that it is. So you can put it in words. I'm not sure that you can capture it in a code. I disagree with the critics of people like of book like Reading Law, where Justice Scalia and Brian Garner try to come up with a bunch of rules. I'd say that it looks like a lot of the rules that are in there in a book like that, but that's not. It's not an algorithm, of course, but it can be captured in words for sure. But I think there's an ambiguity in the claim that the text of the Constitution is law. I think that it is. I just wouldn't say it's the law. And just by looking at it, we know what the law is entirely. We have to bring other things to bear on it.
All right, well, let's try the next three. We've got hardly any time, but John McGuinness, Don Drips, and Shakira Sanders.
Why don't you just take one?
Just take one of them? Okay, John.
I defer to others. My question was asked and answered.
I think this encapsulates much of the critique. Reading the paper, I was wondering to whom it was addressed. And if you can solve that problem, it will be different people. Telling SCOTUS the address of Lazarus, okay, I got that much. But beyond that, to whom is this addressed?
I think that's something we need to work out better. I think we're trying to. I think one problem we're having with the paper is we're addressing multiple audiences at the same time, and we need to sort that out better. So.
Well, thank you very much.
Yep.